Yes.
Mute, please, Your Lordship.
One second. Let me get a. Yes. He said go
Your
to the
Lordship,
prayer, right?
yes, see, I was on the prayer, my
Prayer.
Lord,
Yes.
which prayer in the first writ petition, which is part of, Your Lordship, kindly take up
First,
one writ petition 18 of 2024.
Which one?
18 of 2024.
Okay. That's not the
Because
first one.
it
The second
contains,
one.
second one contains the first writ petition also, all facts, material, everything of the first writ petition also. So, Your Lordship may not be required to go into the first writ petition. Based on second writ petition only, we can have the complete argument in both the matters, my Lord.
Yes.
And Your Lordship will see the prayer in the of the first writ petition, which is at page 54.
Yes.
Your Lordship will see that the honorable court could be pleased to issue writ of certiorari or any other writ direction, etc., upon and proceeding with culminated into issuance of minutes of meeting dated 20th April 2022, and after examining the legality and validity and propriety thereof. So the question here is, my Lord, challenging the minutes of which, and after examining the legality and validity propriety thereof, then this court may be pleased to issue a writ of mandamus to withdraw the minutes of meeting dated 20th April, my Lord. And then C, my Lord, pleased to issue a writ of mandamus, any other writ direction in the nature of mandamus, restraining this from issuing any further tender, etc., my Lord, in respect of two projects. And, my Lord, D, in the alternative, without prejudice to this honorable court, may be pleased to issue a writ in the nature of mandamus to pay compensation of 15 crore 50 lakh rupees. So the compensation amount has also been sought in the alternative.
Yes.
In the alternative, my Lord. So far as this compensation amount is concerned, if I have understood correctly, London Senior Counsel has given up this prayer that he is not pressing this compensation amount because he says that it will necessarily require leading of the evidence and determination of the issue. So this prayer was, if I have understood correctly, if I'm not, this was given up by the petitioner during the course of the argument, my Lord.
Yes.
Now, the minutes of the meeting, my Lord, has already seen. I will not take your Lordship to the minutes. Kindly see the prayer in the second petition, which is at page 20.
Yes. Yes.
And in page 20, the issue in the writ petition is
the termination order.
Termination order of 22/12/2023.
Yes.
My Lord, it is being projected as termination order, but I will take your Lordship to the relevant clauses of preliminary agreement and relevant clauses of the this order of 22/12/2023, my Lord. The picture will be clear that the preliminary agreement was not in existence and is not in existence even as per the petitioner, my Lord, because the wording of the agreement is very clear, because everything. So if the preliminary agreement is not in existence, my Lord, the question of termination will not arise, because Lordship has seen that this contract is in. This was basically, this whole project is in two phases.
What if there was no preliminary agreement? Then what is there to terminate?
There was no, Your Lordship. Yes, there was a preliminary agreement that came to an end.
Then what if there was no preliminary agreement? Then what's the necessity of issuing
So
termination
then,
order?
Your Lordship, see, if there was no, Your Lordship is right. If there was no preliminary agreement, so there was nothing.
If there's no marriage, how can there be a divorce? Simple as that.
No, my Lord. So there is no preliminary agreement when he made the case that you give me compensation for 15 crore rupees.
No, he abandoned that prayer.
Now, so if so my Lord, then the very short issue that if the agreement has come to an end, what right petitioner has to come to your Lordship?
Okay.
That is the issue, my Lord.
Yes.
If the
What are you
if
trying
your
to say?
lordship,
What are you trying to project from the prayer?
what prayer I am trying to project, my lord, is that what my friend is seeking to flog a dead horse, sorry, in the sense that the agreement, kindly see the, for that clarity, my lord, your lordship will see the agreement itself, preliminary agreement. That will give, what is
Yes.
this preliminary agreement is an agreement which is giving something extra to my friend's client, then I would have understood. But if it is not giving anything extra, my lord, kindly
Yes.
see one, the agreement starts at page 112, my lord.
Yes.
This is on signed on 9/5/2024, my lord. Kindly see page 113.
Yes. Yes.
Now, my lord, this agreement at 113 paragraph 2 is where first party has decided in line with the policy guidelines, etc. And this is the object of the agreement, my lord. Now, kindly see the last paragraph of page 113. The second party in response to EI floated by Government of Meghalaya for survey and investigation of hydroelectric power projects on build, operate, transport was submitted its offer. So it is the preliminary agreement was for survey and investigation, my lord.
Okay.
Survey and investigation. That survey and investigation
Yes.
resulted in submission of DPR, my lord. And straight away, my lord, I can take your lordship to the other clauses. Kindly see clause 12 at page 120.
Clause.
12 at page 120.
Yes.
The the validity of this preliminary agreement shall be up to a period of 1 month after due date of submission of DPR or signing of IA, whichever is earlier.
What's IA?
Implementation agreement.
Okay. Yes.
So, my lord, 1 month after due date of submission of DPR or whichever is earlier. So, the DPR was submitted, my lord, and implementation agreement has not been signed, my lord.
Mm.
So then this preliminary agreement has come to an end. What is the further scope of this agreement, my lord? All those discussions which my friend has been showing is with regard to signing of implementation agreement, which did not materialize, my lord. And for that, the petitioner made a claim that I have suffered loss of X amount and you repay that amount.
Yes.
Now, this further I read in clause 12, my lord. In the event the project is now found viable by second party after submission of PFR and the first party is satisfied, second party has sufficient ground to establish the project is not techno-economically viable, the company will be permitted to withdraw from project within a maximum period of 24 as the case may be without compensation or liability of first party for expenditure incurred by second party. 50% of the first installment fixed upfront. This ensure commitment of second party, my lord. Now 13, my lord. Subject to first party and second party having satisfied themselves about techno-economic feasibility of project, an implementation agreement shall be signed between the first party and second party within 1 year from the date of submission of DPR or receipt of clearance in whichever the company will have to deposit so and so, my lord. So after submission of DPR, my lord, implementation agreement has not been signed, my lord.
Yes.
And your lordship is aware, my lord, that we cannot come to the court for direction that sign the implementation agreement. There is no implementation agreement, my lord.
Yes.
we negotiated with each other. We tried to work out. We had certain information, etc. But it did not work out, my lord. And when it did not work out, my lord, the decision, kindly see now impugn order in that light, my lord, at 176, 178. No, first minutes, your lordship will see, sorry, minutes is there. First, your lordship will see 131, my lord. 130. 131, my lord. This is with regard to review which has happened taking place. Paragraph 2, my lord.
Yes.
Paragraph 1 on what time. The chairman observed that in view of the inordinate delay in finalizing appraisal report of upper three stage 1 and stage project, which has led to delay in accordance with TEC of 2 projects, it has become necessary to fix timeline for submission replies of developers so and so to the queries raised on DPR submission of the appraisal report by MEPGCL. So they have been corresponding with each other. Lots of technical data flowed from both sides, my lord. Director Generation informed that a meeting was held by MEPGCL with SM Energy Co. on previous date on 18/2/2020, where the pending issues concerning the query raised by MEPGCL on DPR of the Upper Creek Stage 1 stage were discussed. During that meeting, the developer had consented to comply with the technical points raised by MEPGCL pertaining to the surge shaft and hydromechanical components within 1 week, and construction planning and cost estimate of the project within another week, and pending queries will be replied by the developer. A developer, including submission of revised cost estimate within 2 weeks from 19/2/2020. This is recorded. This is filed by my friend only. It was agreed that revised cost estimate in the light of the observation by MEPGCL will scrutinize and clear based on what tariff, which the tariff will be finalized by MEPGCL within 1 week. Modified DPR after complying with the observation of MEPGCL will be submitted by developer within 1 week for acceptance of MEPGCL, immediately after which appraisal report along with revised corrected DPR will be submitted to Power Department by MEPGCL. CEO of SM Energy Co. Limited placed the following proposal for consideration of the government in view of the delay in receiving TEC for 2 projects, which will lead to escalation in the cost of the project. The developer requested for waiver of additional 10% free power to government offered by developer during the bidding process over and above 12% free power to the government as per state power policy. So waiver was sought, my lord, in clause 1. To include the development of approach roads and other infrastructure facilities in the state budget, which will relieve the financial burden on the developer to some extent. 3. To waive off the charges for hydrometeorological data to be paid by developer for receipt of the said data from MEPGCL for formulating DPR for 2 projects. 4. To take into account additional power that will be generated by downstream existing through stage 4
sorry to interject, Mr. Archival General.
Yes, my lord.
Now, what was the necessity of embarking on this kind of exercise if
Yes,
by
my lord.
submissions that, after 1 month
Yes,
of
my lord.
submission to DPR, if no implementation
Yes, my
agreement is signed, that means it becomes a dead
Correct.
letter. So that it becomes a
Correct.
dead letter if in
Now,
15
my
is
lord,
submitted,
my lord.
the DPR
Yes.
submitted is not acceptable. It becomes a dead letter by operation of
So-
the preliminary agreement itself. The whole thing would have died. Now, what was the need
So
for
why
for
why
this
are we
2020
discussing
meeting?
this, my lord?
Why are we discussing this, and
pertinent and
why have these minutes
yes,
been
yes,
generated?
my lord.
Yes.
Yes, my
We are
lord.
satisfied
Very
of course, because
pertinent question, my
otherwise
lord.
be a continuing course of action. Whatever is
Yes, my lord. So
vested
if
with them.
yes, my
Yes.
lord, the preliminary
Yes.
agreement was not in existence. We were discussing about implementation of. We were discussing about giving shape to implementation agreement.
You mean to say that is
Because, your
already
lord,
you mean to say
that
that
chapter was closed.
that
That
chapter is closed
chapter
and
was
this is a
closed.
new chapter entered into?
Hi, yes, your lordship, I kindly come back to clause 12 only. That is the clause only because see, my lord, there is no implementation agreement as on today. Clause 12 and clause 13, my lord.
Right.
That
Okay.
is into all these agreements are in the nature of 2 parts, my lord. That is why first agreement was a preliminary agreement. If
So
it becomes, and that is why
to say that preliminary agreement is ended and this is entirely transaction.
Yes, that
Has that been
transactions
brought
ended,
out
my lord.
in your affidavit?
Yeah, we may not have said so. Everything is said there, my
That
lord,
is an
and clause is itself.
entirely new, like relationship that we entered into with the
Yeah, your
petitioner.
lordship, kindly see clause 12, reading of the agreement itself shows, my
Okay,
lord. Kindly,
just
and my
okay.
impugn order also shows, my lord. My impugn order also shows. I will read that impugn
Right,
order
right.
also, my lord. I will read it very slowly, my lord. Kindly see page 120, my lord.
Yes.
It's in a very black and white, my lord. The validity of this preliminary agreement shall be up to a period of 1 month after due date of submission of DPR or signing of implementation agreement, whichever is earlier.
Yes.
In the event the project is not found viable by second party after submission
Second
of
party is them.
DPR
Second party is the petitioner,
and
correct?
the first party, my lord,
You are the
kindly
first
see
party,
both the
they are the
parties.
second party, yes.
First party, yes, my lord, this kindly see both the parties description is there.
Yes.
First party is me, second party is SM Energico, my lord, and kindly come back to page 120. Again, clause 12, my lord.
Yes.
The validity of this preliminary agreement shall be up to period of 1 month after due date of submission of DPR or signing of implementation agreement, whichever is earlier, in the event the project is not found viable by second party after submission of DPR and the first party is satisfied that second party has sufficient ground to establish that project is not economically feasible, company will be permitted to withdraw from the project with a maximum period of so and so as the without any compensation or liability of the first party for expenditure incurred by second party before the expiry of the period. The 50% of the amount. So these are the mechanism, my lord, and kindly see 13.
Yes.
Subject to the first party and second party having satisfied themselves on techno-economic feasibility of project, and implementation agreement shall be signed between the first and second party within 1 year from the date of submission of DPR or receipt of clearance, whichever is earlier. So the after submission of preliminary agreement, my lord, the second stage was signing of the implementation agreement.
Okay. Yes.
So the question which falls for lots of kind consideration in the writ petition is that if the preliminary agreement as relied by the petitioner or by the respondent has not fructified or not resulted in finding of implementation agreement, would your lordship in exercise of extraordinary jurisdiction under Article 226 direct the state government to continue with the implementation agreement when there are certain objections which have been raised by the MEPGCL without regarding DPR, shortcoming of DPR, submission of DPR again? Your lordship, kindly see the page 130 once again in those matters, my lord. Why? Because purpose of showing is, my lord, that there was some minutes is there, my lord. In minutes, this was discussed. So the question which falls for consideration is 131, my lord.
Yes.
Now in discussion, paragraph 5, if your lordship kindly mark paragraph 2 once again. Director Generation informed that a meeting held between so and so on 18/2 were pending issues concerning the queries raised by MEPGCL on DPR of upper were discussed. During the meeting, developer had consented to comply with technical points raised by MEPGCL pertaining to surge shaft and hydromechanical component within 1 week and the construction planning and cost estimate of the project within another week, and pending queries will be replied by the developer. Have they placed any material before your lordship that they have done it? Including submission of revised cost estimate within 2 weeks from 19 to 2020. This is their undertaking in the committee. It was agreed that revised cost estimate in the light of observation will be scrutinized and cleared based on tariff will be finalized. For modified DPR will comply with the observation of MEPGCL, etc. And then certain concessions have been sought. Give me waiver of 10% free power. Give me you add road in the budgetary estimate. whatever hydrometeorological data which they are required to pay, don't charge anything for that additional power and give a soft loan from MIDC, Milord. These are his proposals which are after preliminary agreement, Milord, for working out implementation agreement, Milord.
Yes.
And it did not work out, Milord. It may or may not work out. That is the issue, Milord. Now kindly see now my termination letter or so-called termination or whatever subject.
176.
Yeah, page 176. I have to only three things, Milord. Preliminary agreement, then review meeting, Milord, and then 176. First paragraph, Milord. Whereas the caption preliminary agreement was executed between you and the government of Meghalaya for survey and investigation of so and so. Whereas the total amount of upfront fee requires to be paid is 125 lakh, but you have paid only 118.75 lakh, showing a failure to pay the full amount after a gap of more than 10 years. This upfront fee stands forfeited as per clause 4 and 8. Whereas you have failed to reimburse. My lord, I will pause here for a moment. My lord, there is no reply that this has been complied. There is nothing. All these are disputed questions. Why do I am not saying that writ court can't go into the contractual matters. Your lordship has exercised the discretion, and your lordship has refused to exercise the discretion depending on facts of each case, my lord. So there is no blanket or absolute rule we say that writ court can't go or this honorable court can't go, Milord. That proposition I am not canvassing at all for a moment. Whereas the total amount of upfront fee requires to be paid is 125 lakh, but you have paid 118.75 lakh, showing a failure to pay full fee. And gap of 10 years, this upfront fee stands forfeited as per clause 4 and 8. So far as whereas you have failed to reimburse the government appropriate state power utility, 50% of amount is spent by the government on investigation and infrastructure work or project totaling 145 and 75 as per clause 16 of the preliminary agreement. This amount has also not been reimbursed to us, Milord. Whereas the clause 9 of the preliminary agreement requires certain milestones to be achieved by you, you have also failed to achieve the same despite numerous opportunities given to you. Whereas the appraisal report of the detailed project report dated 13/12/2015 of the above two projects weighted by MEPGCL showed that projects are not financially viable with a tariff of 9.30 and 8.18 for so and so, Milord. These data, these informations are there with them for a long time to come, Milord. Whereas in terms of clause 12 of the preliminary agreement, it is clearly stated that shall be valid for 1 month after due date of submission of in clause 12 of preliminary agreement has come to an end within submission of so and so. Therefore, preliminary is not existence as of today. Whereas in terms of clause 13 of the preliminary, liberty was given to both parties to only when both parties are satisfied with techno-economic feasibility of the project. If the government is not satisfied for some reason, good reason, Milord, and there is no direction in the writ petition which is being sought by the petitioner to go for the signing of the agreement, Milord. This is a subjective discretion, Milord. Whereas government of Meghalaya is not satisfied with techno-economic feasibility of the agreement, therefore it is liberty not to enter into implementation agreement. So what we are saying is that we are at liberty. Now we quote here, Milord, the proposals given by the government, whereas the said terms and conditions are not acceptable to the government and also amount to post-tender modification and also not in public interest, Milord. Whereas you have also shown complete apathy in pursuing the matter in right earnest, which has led to inordinate delay and have failed to attend the review meeting, so and so. Whereas you have raised artificial, fictitious claim, bogus claim of 15.4 crore, where state has suffered loss on account of your act and omission, you have no basis to claim. Now, whereas the state is entitled to be compensated for losses caused by you in inordinate delay, the project and defective DPR and also making the payment in terms of preliminary agreement. Now, therefore, in view of the above and exercise of power under clause 29 of the preliminary agreement, it is reiterated that preliminary agreement is no longer in existence. Said aspect is hereby informed you by way of abundant caution, Milord. So, what is the issue before your lordship is that if the preliminary agreement which has come to an end and information to the said effect by the government to the party is per se liable to be challenged before this honorable court by way of writ petition. And I assume and I argue the case against myself, my lord, and I take it that this order is set aside. And they succeed in getting the relief from your lordship. The effect would be preliminary agreement is already dead now. Implementation agreement has admittedly not been signed, my lord.
Yes.
If there is no implementation agreement, there is nothing, my lord. Now the question of financial liabilities of party inter se will be remaining, my lord, whether I am entitled to recover the amounts which I have mentioned in this agreement or not. Whether they are entitled to recover 15 crore rupees for me or not, my lord. Because they have also sought compensation in this letter, though in the writ petition they have given up the prayer.
If I correctly understand the arguments of the petitioner's side, is leaving aside all these other things, is that they are questioning the decision-making process as how you arrive
Now the
at this termination letter.
now, my lord,
Now that's the thing.
now
The thing is that, see, whatever it is now, even a termination letter, though you submit that the preliminary agreement is a thing of the past, and that has, by influx of time and by circumstances, is dead.
by the cross
But
12
then you have referred to that, and same time is that decision-making process, and whether it's entitled to the opportunity of hearing or not. That is what
yes, my lord,
decide. And whether if it is seen that yes, he is entitled to a opportunity of hearing, notwithstanding the fact that maybe you don't look preliminary agreement also, but by rule of law and in whatever he's entitled before the termination is done. Now, whether that offends the principle of natural justice, and whether your termination letter is reasonable, that's all. The court's not to examine the the nitty-gritty. It's going to go into it's just going to go into the decision-making process. Judicial review in this case we limited to that only. Yes.
Yes, my lord. Yes. Now, my lord, the as your lordship has rightly put, with the process.
Yes, the process of decision making. Now you have to show
process
that it's transparent.
Process, yes. So whether process in law or process which has been followed by government required compliance of principle of natural justice.
Yes.
That is the core issue which my friend has argued and the place. Now the question which falls for your lordship's consideration is this, my lord. When contract provides for certain situation or certain things to come out or certain things to take place, whether in those processes also, my lord, when parties are saying that the contract will come to an end within 1 month of submission of DPR or signing of implementation agreement, whether there would be requirement of law to give so-called notice for implementation of the clause, my lord. In my humble submission, are we not reading too much in the contractual relation between the parties, my lord? It is basically commercial relationship between petitioner and MEPGCL or Ministry of Power, where Ministry of Power wanted this project to be built on build, operate and transfer basis, my lord. It is all those judgments which have been read, my lord, all those are statutory character, statutory nature. When contract between two parties, whether it's a government or private entity, my lord, provide that contract will come to an end on so and so date, my lord. Whether in that event also, if the due process in the sense that issue so-called notice why the contract will not come to an end in terms of clause 12, in my humble submission, that will be far-fetched and not in consonance with the practice, commercial practice or practice in law, my lord. Why do I say so, my lord? For reason is, my lord, that the clause is very clear. I have signed this agreement with my open eyes. My friend's client has also signed with his open eyes. He says that, look, I will submit my DPR. If the DPR will result into the economic feasibility, implementation agreement will be signed. Government has analyzed. They are not questioning the technical. They are not asking your lordship to direction to sign implementation agreement. If your lordship will issue the direction as of now also that, look, your process is wrong and the process is wrong, because you should have in terms of clause 12 or clause 13, which I failed to see, my lord, in the argument of my friend also. Where is that? How do I read the principle of natural justice in clause 12 and 13, my lord?
Yes, let's see. One.
Because that will be in all contractual matters, my lord, because government has been entering into the contract with so many parties, my lord, and those are all commercial terms. Kindly see page 120, my lord. Then in all those cases, government will be bound to issue notice even for implementing the contractual terms, my lord. And there are a series of judgments, my lord. Our case law is well settled on this issue.
For termination, notices.
This is a contract which is coming to an end with by virtue of clause 12, my lord. The validity of this preliminary agreement shall be period of 1 month after due date of submission of DPR or signing of IA, whichever is earlier. My friend's client knows, I know this, that DPR has been submitted on 15th. The precise date, my lord, is my friend, and 30/12/2015, my lord.
Yes.
So then this clause says, my lord, that it is come to an end. Where is the question of giving notice to my friend, my friend's client?
Yes.
And clause 13, my lord, kindly see. 13, my
There
lord.
was a chart regarding that where he said that, if any.
I will deal with that also,
Yes.
my lord. I'll show that part also, my lord. 13, because this is the most important part. Subject to the first party and second party having satisfied about themselves about techno-economic feasibility of project, and implementation agreement shall be signed between the first party and second party from the date of submitting of DPR or receipt of clearance. Having, so requirement is satisfied themselves about techno-economic feasibility, my lord.
Yes.
Then I will sign the implementation agreement, my lord. So if there is no technical or economic feasibility and I am not satisfied, my officers are not satisfied, my lord, for reasons good, bad or ugly, my lord, and there are numerous reasons, my lord. Kindly see, this is a project of 2014. Nothing has moved, my lord. We are at the stage of DPR only, my lord. Now time has moved, and where if there will be a project, my friend's client is free to participate. Better projects can come. It is in the public interest that we should have more hydroelectric power corporation. We want to expedite it also, my lord. Can we get stuck in the project which is not moving for last 10 years, my lord? Fault is mine or fault is of the petitioner. I don't know, my lord, that those are the questions which will be gone into in the civil suit, my lord. Now kindly see the other clauses which my friend has read out, and I will read out also, my lord. Kindly see 114, my lord.
Yes.
The first party has accepted the proposal of second party and has agreed in principle to allow them to investigate the project subject to fulfillment of terms and conditions of this preliminary agreement by second party. These are the details, my lord. Second party can explore the potential of the scheme to attain higher capacity if possible. However, such available capacity should be limited to the assigned domain. Within 2 years, as the time may be as the case of signing of preliminary agreement, the second party shall furnish to the government the following: and compendium giving details of hydrological and meteorological data observation, topographical sheets prepared after conducting surveys, a compendium giving details of geological and geophysical observations, a report on the power evacuation arrangement envisaged by second party, feasibility of the project. In case the second party is not able to furnish the above document within stipulated time, first party will be at liberty to cancel the preliminary agreement after affording due opportunity to second party. No compensation whatsoever shall be payable by the first party in this regard. The upfront premium deposited by second party shall also be liable to be forfeiture. 5. Second party shall carry on techno-economic studies of the project and submit detailed project reports to the first party within 36 months from the date of signing of preliminary agreement. The first party will be at liberty to cancel the preliminary agreement after opposing due opportunity to the second party. No compensation whatsoever shall be payable by the first party in this regard. The upfront premium deposited shall also be forfeited. 6. In case of delay being unavoidable to the satisfaction of first party, second party may be granted extension upon maximum 6 periods of submission of DPR upon payment of 10 per megawatt. 7. Second party shall carry out requisite detailed investigation and identify the transmission line, etc. integrated. 8. In case of failure of second party to adhere to the benchmark as preliminary agreement, so and so, in case of breach of provisions, my lord, following milestone 9, second party which consequential action, my lord, these are the milestones. So all these milestones lead to, my lord, DPR, my lord.
Okay.
10, your lordship will see page. The second party agree to supply free of cost the hydrological data. The first party shall have right to use the data. Any 11, second party agree that fixed upfront premium defined and so and so, my lord. So ultimately, all these milestones lead to DPR. After submission of DPR, next stage, my lord. And that stage has
all these milestones,
yes,
and a preliminary agreement is only confined to DPR.
and
if
to
the DPR
DPR,
is accepted, techno-economical feasibility is fine, then you go and sign implementation agreement.
Implementation. So this is a kind of agreement which was in the nature of two-stage agreement, my lord. And I have shown
what the court can't understand is, if you see this is one part which is totally removed from the second part, then why do you refer to it in your termination letter? That's all.
Now, your lordship, kindly see the white. Now, what has happened that my friend's client has raised a demand.
Before you
raised a claim, your lordship will see the need for writing because now we want to go ahead, because they were saying that we wanted to have a fresh look and at the entire hydrological capacity of the Meghalaya, my lord, and we wanted, and therefore my friend's client raised a claim, my lord. Kindly see and therefore, my lord, assuming, my lord, notice will, whether no termination will give them right or right will flow from the agreement. That is a question which I must answer, my lord.
Right.
And the right will not flow from the termination. Right will flow from the agreement only, my lord. I have not come across a case where
the termination, how this is,
and it is not a termination, my lord. How I do not read with greatest respect, my lord. My friend has read it termination. I kindly see 176 again. 176. What is
I hope we're not moving around. We're not moving around circles. Yes.
Only because I'm not half an hour, 15 minutes. My friend has taken. I have to not gone into any other. Only issue, my lord. Only 3 pages I have been showing agreement.
No
176, my lord.
Yes, no worries about that. Yes.
177, my lord.
Yes.
Now this is subject my friend has read. Termination of preliminary agreement. Termination of preliminary agreement. This is the subject, my lord. And kindly see the last page 177.
Now therefore,
in view of the above fact that exercise of power under various clause 29 of preliminary, it is reiterated the preliminary agreement is no longer in existence. Said agreement is in fact by way of abundant caution. If the entire letter is read, my lord, and kindly see clause, sorry, I did not place the one, I should have placed that clause 29 also, my lord, because there is a reference, and your lordship will find that clause at page 29 at page 125. Any violations of the above mentioned issue concerning policy parameters PA/IA may result in monetary penalty, including cancellation of the project. 30. Any difference and or dispute arising at any time between the parties of this PA or IA or interpretation therefore shall be endeavored to be resolved by parties mutual negotiation. All disputes shall be settled within the jurisdiction of courts of law. Review meeting took place and this could not be resolved, my lord. That which I have placed, my lord, at page 131. So if your lordship, in my humble submission, if the 22nd December 23, my lord, is capturing the development of this entire project since 2014, 9/5/2014, my lord, and we are almost 10 year, 1 decade has taken place. This project has not moved a single inch, either because I say that if I show, my lord, review meeting is very clear that they were required to do a number of things. They did not, and they were required to come back, my lord. They have not made a single averment, my lord, that they have come back at page and they have done it. 131, your lordship will see that paragraph 131. Paragraph 2 is very clear, my lord. It is a public interest litigation, my lord. It is a public interest which is going to be badly impacted if we delay the project by a person who is not able in position to develop the project. The director informed that
he's just saying just give me a fair deal. That's all. If if this is the
because
situation,
we are also asking for a fair deal, my lord. We are at the mercy of, in the hands of developer in almost all projects, because we have not been able to take action against them and they have not been able to deliver if they give the DPR, which are useless and meaningless, what do we do, my lord? And the project is, your lordship has seen, number of projects in Meghalaya are not moving a single inch. Because every state government may be fair deal, public is also requiring fair deal, my lord. Kindly see paragraph 2.
yes.
What? Director Generation informed that a meeting was held by MEPGCL with SM Energy Co. on previous day on 18/2/2020, where the pending issues concerning the queries raised by MEPGCL on DPRs of upper so and so were discussed. During the meeting, the developer had consented to comply with the technical points raised by the MEPGCL pertaining to the surge shaft and hydro mechanical components within 1 week, and the construction planning and cost estimate of the project with another 1 week, and pending queries will be replied by the developer, including submission of the revised cost estimate within 2 weeks from 19/2/2020. 3. It was also agreed by that revised cost estimate in the light of observation by MEPGCL will be scrutinized and clear, based on which tariff will be finalized by MEPGCL within 1 week. Modified DPR after complying with the observation will be submitted by developer within 1 week for acceptance of immediately with appraisal report along with revised plans. And then CEO of SM Energyco is saying that give me budgetary support, give me 10% free power, give me post-tender modification. We did not agree. So when we were negotiating, my lord, there is a negotiation which is going on. Now, the party comes to your lordship, petitioner comes to your lordship saying that the state has not acted fairly. I completely fail to understand. When we are implementing the contract, I am implementing the clause 12, I am implementing the clause 13. Where did I not act fairly? My project public interest is because the hydroelectric power generation would have helped the public. We would have earned the money if the project would have been developed in right fashion, right spirit, my lord. They are saying, they are not denying. Kindly see that cost of electricity, is it viable project, my lord? Now they say that they are giving the cost, they are not denying that their cost of electricity is 9 rupees or 10 rupees, my lord. When in the market we get the electricity at the rate of 4 and 5. So if I have to invest money and I get the electricity at the hydroelectric power at 9 rupees, that is not technically and economically feasible, my lord. Your lordship will not burden the state with a project which is technically and economically not feasible.
There's no question of burdening. It's just a question of, again, coming to the same point, is whether,
no, because what they are saying, because what they could not achieve directly, they want to achieve indirectly through your lordship's writ judicial.
Mr. Abdul, the court cannot issue a mandamus that to settle whatever contract or to sign in
I
principle.
bow down.
That is out of the question. There's no question. The only thing is that maybe revisit your decision, like whether whether cogent reasons are there.
We have struggled for 10 years, my lord. In the facts of the case, my lord, everything is writ large, my lord, here, open, my lord. This is not workable. And if my friend will not, if he has any, he has got the technical expertise, projects will be hydro, if he has also already implemented some of the projects, and hydrological projects will be coming, hydroelectric power projects will be coming, he will be making the bid, because judgments which we read by my friend was regarding blacklisting. We have not blacklisted. Your Lordship is already saying one blacklisting matter. We have not blacklisted. We have not taken any action. We have only settled the financial terms, because if I do not issue this letter of 22nd December 23, my lord, how do I settle my financial terms with the contractor, my lord? That you are not entitled to 15 crore rupees, I am entitled to X amount. Let them reply to this letter. But the preliminary agreement is already dead, my lord. I need not burden your lordship with the. I have got the compilation of judgments. I can place all those judgments which I have been placing time and again, my lord. But my short case is that clause 12, clause 13 of the agreement leave no scope of doubt that the agreement has come to an end. Parties have not. There is a clear cut. The order or review meeting of the government clearly shows that government has formed the satisfaction that it is not technically and economically feasible on the basis of whatever DPR or correction they have made. And thirdly, my lord, the agreement, this is not in the nature. This is only information to the parties of respective rights in the contract. This is which is based on the subject, my lord. If your lordship will see, based on the subject, title of the document will not decide the nature of the document, my lord. That is just if the subject is termination is being read termination, but if your lordship will read the entire and has seen, it is only clarifying the legal position which is expressly stated that it is being done by way of abundant caution. So this is my total submission, my lord. I have got the compilation of judgment, my lord, but I need not burden you.
Petition?
The maintainability, because your lordship now, yes, your lordship has seen technical feasible, because whether it is technically feasible or not.
Now you see that now they've raised arguments also prior. I mean, expecting what how do you say it is maintainable?
Now, so question of maintainability.
You have no quarrel. We have no quarrel. The petition is maintainable.
No, I have a quarrel, my lord. Why? That's why I want.
You have not addressed any arguments on that. So you've kept quiet about that. So the court will take it that
what
yes.
Has fallen from, Lord, what has fallen from your lordship? What has fallen from your lordship is that this court is not going to issue writ of mandamus to the state government to enter into the contract.
But then it doesn't mean that this court cannot issue other orders or a different writ.
So now
it doesn't mean that we cannot issue a mandamus for settling any contract with them.
Yes, my lord.
But then so they have come before the court to complain that I've been treated unfairly. This is what has happened. So how the court address that? And if you say that it's a contractual dispute, the is not maintainable, then you make arguments. Otherwise, we will totally overlook that part. All the Harbarla, Sania or ABL will all we don't need to discuss that also. Like is the writ maintainable, and we'll go into the meat of the matter.
No, my lord, that will be too sticky wicket for me to do that, my lord. Now the issue is, my lord, that why do I say that writ is not maintainable for this kind of or this type of contract, my lord, in contractual matters? With the caveat which I have already added, that I am not saying that the Article 226, which is extraordinary writ jurisdiction, cannot be exercised in appropriate cases, my lord. That principle is settled, my lord. I need not trouble your lordship with that principle. But your lordship has laid down certain norms.
Not trouble the court or make it easier for yourself.
No, my lord.
So that is what. Yes. That means troubling the court. Lord, I mean, if the court has
lordship, kindly see.
Yes.
My list of judgments are there, my lord. Kindly see those judgments.
Yeah.
I will deal, my lord. But factual parameters first, my lord. Why I say so that it is involving disputed question of fact, my lord. Why it is a disputed question of fact, my lord. One, for the reason, my lord, is that what is the prayer which the petitioner that there should not be termination.
Yes.
Now, sorry, first point, my friend had, now I remember all the arguments against me, because I was, first argument of my friend was that principle of res judicata. I have raised that objection and I have to answer that, my lord. Now, my lord, the first writ petition is also against the so-called meeting, so-called minutes of the, they challenge minutes of the meeting,
Yes.
where the decision of the chief minister was to cancel the project.
Yes.
In the second writ petition is also same prayer is there, my lord.
No, second petition is, I'm not arguing on behalf of the petitioner, but the
Yes,
dimension
your
has
lordship will,
changed.
yeah,
Dimension in the
but your
sense that,
lordship definitely,
he
you
had
can lordship
given
may,
birth, another cause of action in the sense that the
yes, my lord. So
termination order was
now,
issued.
now what they are saying is that second order, first was not a, first was termination, and second is, first was not a termination, my lord,
First was the
if I understand.
minutes whereby it's
Minutes,
been
minutes,
recorded that
can you
termination.
lordship see,
And
can you see the
second
minutes, my
repression
lord?
is regard to the with the tangible, like, order has been issued by the respondent. That's all. Yes.
So, my lord, so both are, is in essence, in my submission, my lord, humble submission, is one and the same relief.
Okay.
My case is
That
that
will
both
notice.
are
So you see, it's identical relief.
identical relief, my lord.
Yes. Same cause of action.
My question, yes, same cause of action.
Okay.
Whether can you maintain two writ petition for the same cause of action?
Yes.
In my humble submission, it is not maintainable, my lord,
Yes.
because the cause of action is same, my lord. So this paragraph, first judgment is, my lord, on that issue, my lord, Orissa Power Transmission Company versus so and so, paragraph 32 and 33, index itself, it's there, my lord.
Yes.
And your lordship, that is that the two writ petitions are not maintainable on the same cause of action, my lord. That is well settled proposition of law to be. I am only second judgment also is on that only, my lord. Then that is also 2017, 5 SCC 496, paragraph 13, your lordship, may 13 at page 31, my lord.
Only the problem is that it has been supplied just now. So I have to really go through it, because his whole case is that is adjudicator, he's saying.
You have to chew on it.
Yeah, I have to go through it. Let him complete. So only, my lord.
No, he's
only,
a bit. He's
he's
just
not
traversing here and there.
why-
He's very cleverly arguing his whole matter.
very cleverly, very.
My first argument is,
Not the usual style of arguments. You know?
my first argument is, Milan, that there is nothing in the writ petition on, there is no cause of action in the writ petition, Milan, because it has come to an
Because you
end by
see,
virtue of.
Mr. Advocate General, you caught the case by the tail first. That's what's happened in this case. Instead of going at the maintainability part, you have caught it from the tail. You've gone to the merits of the matter, and so that puts you on a back foot with regard to maintainability. You've addressed that, saying that, and then you've proceed from there and on the query of the court.
No,
So it's a bit confusing.
the reason was, Milord, this
Yes.
time I did this, Milord, because first I had to satisfy your lordship on merit, then I have to go into the,
Of course.
because if I don't satisfy on the merit, I won't be able to satisfy your lordship on the maintainability part also. So I thought that first let me place my
You kill the
case,
case
which,
on merits, so you need to go to maintainability. That's a first.
because and then your lordship will use the whatever spear in the armor. so paragraph 13, my lord,
Yes.
at page 31.
Yes.
This court must view with disfavor any attempt by litigant to abuse the process. Sanctity of judicial process will be seriously eroded if any such attempt are not dealt with firmly. A litigant who takes liberties with the truth or with the procedure of the court should be left into no doubt about the consequences to follow. Others should not venture along with the same path in the hope or on a misplaced expectation of a judicial leniency. Exemplary. So this was again 2-3 litigation, my lord, filed on the same issue, my lord. So this was the message which the Honorable Supreme Court was trying to give, my lord. Third judgment is, my lord, novel resources, paragraph 43, my lord.
No, but in this case, you see, it's like you read para 12. This case indicates a blatant abuse of the process of the court. The petitioners not only took the benefit and order of the High Court granting them 1 year's time to vacate premises, but obtained a further extension
Correct.
of a period of 4 months to vacate. Then they filed a review petition for
Correct.
the High Court, and they moved on application,
Yes.
seeking extension
Yes,
of
my
5
lord.
years.
That was a gross case, my lord. That's why it's a
This is a
gross
gross
case where
abuse.
the court has
Now,
gross
whether
abuse, my lord.
yes,
That is
okay, next case.
no, it's not strict sense. I would not. I would be fair, my lord. That is not the. But only thing is that on the same cause of action, you can't maintain multiple litigation, my lord.
Right.
That is
So
what I
that is
say.
a given. Yes.
That is the
Yes.
only thing which I have to say. Not now, your lordship. Third judgment is on a specific relief act, my lord.
This is Nobel.
Noble Resource versus State of Odisha, paragraph 43, my lord.
Yes. This is a settled position.
Now, your lordship, I think this is the settled principle of law, my lord.
We're not going there
Because,
also.
oh yes, your
we're
lordship.
not
So
going
then
there.
I leave that part.
Leave that out.
That then your lordship will, yes, my lord. So then therefore I come to my lord the second
Artec.
specific relief. Yes, my lord. Then my lord 2014 SSC online. Then this is also again those are specific relief act, the OPG etc. My lord. Lordship is not touching that aspect.
No.
So then. Now, your lordship has raised that issue also of delay.
Yes.
Delay.
You have not argued on that point at all. On the delay.
Because I'm now, no, it is there in my counter, but my senior counsel has raised that.
General, you can,
Yes,
you can what do you call it, categorize your arguments. We'll have you short.
I will put it in bullet point.
You put bullet
I
point,
will
and
give
we'll
it
hear
in
you
bullet
again,
point.
like,
I'll give it in bullet point.
We'll give you a brief hearing. So at least,
Yes,
otherwise, to note down it became a bit difficult. Yes.
I will give in bullet page, and I will give it in advance so that my bullet point will be there, and that will with the reference to the page number also.
Thus,
if what I feel, your lordship is hearing the matter. Otherwise, if it's too long, that your lordship will get.
Long, after a week, be fine.
Yes. On. Okay, he can. I don't know the list of your lordships and how the list goes on. Tomorrow, if he's finished tomorrow, then I will not be there. They will be there. Day after tomorrow, I can reply and finish it of the matter. If it is convenient for the court.
If it's
subject to
both of you should be here.
Yes, convenience of the. But I thought
only difficulty.
I thought that
arbitration.
I thought AG will come. He is saying that other matters he comes, he doesn't come in his matter.
No, I will be there in your the arbitration final argument matters of state are listed here for next 1 week. In second half also so therefore I am tied up this week.
We'll have it next after 1 week. Yes, we'll finish it off. You don't keep only that we need some clarity. On the line
I will put it in the bullet form.
I will the line of your defense. That's it.
Yes, I will put in the bullet formula. I will put it in the bullet form.
Yes, hearing inconclusive. List on so and so.
It can be on 38th, my lord. 30. 38th?
30th Friday, no, it'll be 29. We'll put on 29.
29, lot of matters are there. 30th, let him finish off the matter. 30th. For few, he'll take about half an hour, 1 hour. 30th.
No, he still, you see, the things that he has not really, his arguments have not become sequential, and then
he started from
he
merit
started from the end. Yes.
from end.
Yes.
So 30, if it is not incurred, let him.
30th.
30th, 30, it's possible.
29th, your lordship may have it. 29th.
I have some problem. That's why 38.
Okay.
Because Fridays,
so he should. One request, my lord.
Notice.
One request.
So
one request.
30th, your lordship may have it in 30th.
38. Let him come here. One request. He
No,
should come here.
I then have him in the first week of September. Then I will be there because there are 3-4 matters continuously.
No,
Limestone, everything.
38. because your Lordship is hearing this matter. Otherwise, you'll be distracted. Let it be on 30th. We'll try.
It's not just matter. There are many matters that are
I
running.
know.
They're running concurrently.
30th is also a BSc arbitration, is full day arbitration is there. May I request for Monday? Monday, 2nd September. Monday, my lord. Monday.
No,
Monday.
it's not
Monday.
possible. Second is I will be out of station on second. Fourth may be possible.
So can you do something? Discuss among yourselves and give the date.
Yes, I'll discuss. Yes.
I'll do that.
Or else it become as a
I am deeply obliged, my lord.
yes. List on sir. All the parties represented. Where's aim of Sora?
Your Lordship, the previous counsel withdraw from the case, so therefore I'm appearing for today.
Why do you withdraw from the case?
Number 6. Yes, Your Lordship.
You are appearing.
I already filed.
My friend is the newly appointed counsel.
You are appearing alone or with Mr. Mahanta?
With the senior counsel.
Let them come. It's better also that council is not yes
Because there would be that other element also that your Lordship.
some orders have to come. It's very unfortunate.
But Malaj, in that event, Malaj, what I was again submitting before your Lordships is, and I just found one judgment that before your Lordships would proceed with this matter, Malaj. Now, since there is a contempt which is on the face of this honorable court,
Yes.
and Malaj, I think some proceedings would have to be drawn up, and there would have to be the contempt part of it would have to be purged.
Yes.
So
Yes,
to that
we just
extent,
finished that.
Malaj,
We just finished that citation for the judgment. Yes. We just record that she is appearing today. She do you respondent number?
Malaj,
Number 6.
in the
Number
petitions.
Yes. 6.
Applicant in the missed cases.
Yes. When the matter is taken up, it is submitted at the outset. That on behalf of number 6.
6 and 7.
6 and 7.
On behalf of 6 and 7, the earlier counsels have since withdrawn, and Mr. S.P. Mahanta, along with MSLDN, thank you, have been engaged to appear in the matter. The same is noted. Establish this matter for when? After 2 weeks, you prepare. Then we, okay, yes, give him ample. He's not well also, Mr. Mahanta, what's happened to him?
Oh, he's not feeling well, Your Lordship.
He's not feeling well or he's not well?
He's not well.
diabetes is
Difficult, yes. Yes, okay.
the judgment. I've just placed it
Yes,
before.
that will just take it
Oh, Your
privately.
Lordship, for respondent number 7, it's already been dissolved by the committee.
What is
Doesn't matter. That you make submission later on. Yes.
The
Yes.
relevant paragraph of the judgment, your Lordships, have para 8 and 9.
Thank you.
Purging the contempt. Right.
Yes. Where's
My friend Mr. Datta is online, Malaj.
yes, Mr. Datta.
Your Lordship. Lordship, will it be convenient if it is fixed on 27th?
What about you, Mr. Paul?
There is some urgency, but my friend has also made a request. We can have it on the 27th, subject to your Lordship's kind convenience. Because your Lordships have heard us at length on this matter, Malaj. We can try and conclude the matter.
Obvious. At the request of Soon's parties, husband 27th.
Lordship,
We'll also
can you
prepare
on
a short
27th, Lordship?
bulleted point, Malaj.
Yeah, 27th.
At the conclusion of our submissions, you can submit it. So your
Escrow account, correct?
I'm sorry, escrow account.
Yes.
Escrow account.
Interesting matter, yes. You ready? Mr. Datta, 27th.
Yes, Lordship. Thank you.
Yes, private respondent.
Yes, Your Lord.
You're for number 4.
Yes, Your Lords.
Yes.
May it please your Lordship.
Yes.
Your Lordship, as per the order dated 25/9/24, Your Lordship,
What was that
2024.
order?
2023.
25/9/24.
2023, Your Lordship. Sorry. Just to refresh Your Lordship, this matter has already been heard.
Yes. Yes. Are you agreeable to share 50/50?
No, Your Lordship, you
Why?
are not agreed. Because, Your Lordship, all the documents are fake documents and we dispute
What are
the...
fake documents?
Because the marriage certificate, birth certificate, everything is a fake documents, Your Lordship. And we try to talk to them also, both the party. So here like...
People gone for mediation.
Your Lordship, here what happened is that the petitioner herself, she went to Nepal, Your Lordship, because now it's 5 years since her husband had passed away and she has no means to support herself, so she has to return. Now all the way from Nepal she came, Your Lordship, for talks, but then they are not agreeable.
No, okay, we'll hear it then. Open Thai bank. Yes.
Your Lordship, initially when we filed this writ petition, Your Lordship, we were aggrieved by the impugned letter dated 17/2/2022.
Where is that?
Page 58, Your Lordship, of the writ petition. Annexure 15.
Page 58.
Yes, Your Lordship, Annexure 15. Here, Your Lordship, the office of the respondents, they have asked us to produce a succession certificate. They have never disputed that I'm also not the wife. I am the second wife, Your Lordship. Now, because of this, Your Lordship, I approach this honorable court. Because, Your Lordship, pension is not a debt or a security, Your Lordship. That was my prayer before this court, to quash this, Your Lordship, and to release the pension in my favor. Your Lordship, while submitting also the representation for claim of family pension, I've clearly mentioned that I have no objection if it's shared, because I do agree that the minor daughter is also eligible, entitled to claim a family pension. Now that is the only thing, Your Lordship. Now after we filed this writ petition, now the private respondent is coming up with all these allegations. Now, Your Lordship, with regards to the marriage certificate.
Let's see this. What is this? What is this? You agree with this? Read. What does this order say? Annexure 15.
This order has only asked us to produce a succession certificate, Your Lordship, since we are both entitled.
Advocate General gave what opinion?
That both of us are entitled for share of family pension.
Okay. Yes.
Yes, Your Lordship. Now, with regards to the marriage certificate and the death certificate of the first wife, Your Lordship, they're alleging that it's fake. However, Your Lordship, I was not the one who submitted those documents before the office. It was my husband who got it registered and submitted before the office.
Where are the documents? Are they in your petition?
Yes, Your Lordship. The marriage certificate is page 20, Annexure 1.
It's in Nepal.
Yes, Your Lordship.
Okay, Annexure 1.
And then the marriage certificate or the death certificate is page 21. Now, Your Lordship, if we peruse from the rejoinder affidavit, Your Lordship.
And the death certificate is?
Death certificate is page 21, Your Lordship.
Page 21?
21.
21 is, okay, yes.
Oh, that is
Type
the
copy.
birth. Yes, type copy. Page 21.
Yes. Yes. Okay.
Now, Your Lordship, if I may take Your Lordship to page 23, Your Lordship, of the writ petition.
Yes.
The third paragraph, after the death of late Om Kumar Lama,
Yes.
Ms. Yam Kumari Tamang, that is the petitioner, personally appeared before the office and submitted his death certificate, the death certificate of the husband, along with birth certificate of his 3 children, those including of the first wife, Your Lordship.
Yes.
So, Your Lordship,
So
I feel...
yourself you didn't give it.
Yes, Your Lordship.
Okay. Yes. Yes. Then?
Then, Your Lordship, if we also peruse the rejoinder affidavit, Your Lordship, it's very much clear from all those annexures there, Your Lordship, that I was the one taking care of him till his death, Your Lordship. Page 12, Your Lordship, of the rejoinder affidavit.
When did you get married to him? As per the first marriage?
2012, Your Lordship, after the death of the first wife. And, Your Lordship, it's not disputed that the first wife has already died. It's not disputed. It's not like she's alive.
Yes. What are your options in the rejoinder?
In the rejoinder, Your Lordship, I just wanted to show Your Lordship regarding that I was taking care of him when he was very ill.
No, that's all right. I mean, yes. Yes, state.
May it please Your Lordship.
Yes.
Lordship, so far the state is concerned, Your Lordship, we have no problem in releasing the, provided there is a settlement between them, Your Lordship. Because, Lordship, there are rival claims, Your Lordship. So if that is settled among them, then certainly
No, not settled among them. Now the fact remains that she is produced a marriage certificate, death certificate of the husband, and also that the fact the first wife has died. Simple as that. Correct.
Lordship, yes, that is correct.
And so then the children is number 5, the child from the first wife.
Lordship, yes.
Yes. So that's it.
Had not been made party, Your Lordship.
Who?
Your Lordship, because
Other
he's
side
already
has
a
not
major.
been made party, Your Lordship. We have
Not majors yet.
He's already a major. Only the minor daughter is
2003,
eligible.
Your Lordship. Son, he's also a
You
state.
come forward. Why are you submitting from behind like that?
Because, sir, came.
Let
You're
them
afraid to
settle.
stand by his side.
No, Your Lordship, sir was giving submission. That's why I gave a space for him.
Let them settle, Your Lordship.
No, there was a direction settled. Otherwise, we'll order you pay 50-50. What is there?
Lordship, yes. That is what we if Lordship kindly come to
I don't know.
the-
The court can direct because as per the what's that rule 48? What does it say, Mr. Shulai? Rule 48. You have to pay only one entity, correct? Family pension.
Lordship, yes.
Then
First is the widow. Widow is eligible.
yes, first the widow. Now family pension you can pay only one person. How can you split 50-50 unless they agree?
Your Lordship, because the Meghalaya service rule is also paramaterial to the civil service rules,
Yes.
Your Lordship.
So only one person can get.
Lordship,
According
yes.
to that, both, Your Lordship, it should
Where
be-
where does it show?
According to the civil
see
service
that.
pension rule.
Where?
I do not have it with me, Your Lordship,
Why
because
don't you have
this
it
is...
with you?
Lordship, I kindly come to the affidavit filed by the state, Rule 48.
Where's rule 48? You've quoted here.
Lordship, yes. That has been
Affidavit President number 4, number 1 to 3.
1, 2, 3, Your Lordship. Aku badan bat enclosure.
GG movement.
Lordship, yes.
Yes.
Kindly see Rule 48.
You look it up from here. MS Sawian here.
Kadang tu ke affidavit dan
Yes.
berkait.
Yes, which paragraph?
Lordship, kindly have a look at Rule 48. Your Lordship will find at page 39.
Of what?
That affidavit, Your Lordship, it is there in the affidavit.
The affidavit is only 7 pages.
Lord.
How will get?
Sorry, Your Lordship, this one.
Yes.
Family, for the purpose, Lordship is 48.1, Your Lordship, I. Family, for the purpose of rule in this case, will include the following relative to the officer: Lordship, A, we are not B. Lordship, A, wife in the
Unamended,
case.
this one.
Then Lordship,
This is amend. This is.
no, Your Lordship.
See, look at this one. The note to marriage after retirement will be recognized. Why? Now it's recognized. Marriage after retirement.
No, Your Lordship, this is the.
See, 48. Just see 48. What does it say?
48.1 says, family for the purpose of rules in this section will include the following relatives of the officer.
Lordship, wife
in case of the
of
male officer,
male officer.
husband in case of female officer,
Then minor son,
unmarried
and unmarried minor
And note
son.
1.
and will include children adopted. The note 2 is
Yes.
marriage after retirement
Yes,
will
Your
not be
Lordship.
recognized for the purpose
For
of
this,
this rules
section.
in this section.
So going by this rule 48.1, A and C, Your Lordship, because admittedly the. It's minor.
And married minor daughters.
Lordship,
She's
yes.
married.
Unmarried.
Then you share 50-50.
Lordship, that is.
I may be allowed to say something, Your Lordship.
Of course, you can see something.
Yes.
But that's what the mind of the court. Why are you resisting?
No, I'm not resisting, Your Lordship.
Then, why not accepting? Why do you take all of it? Why you want to dispute the marriage certificate?
Yes, Your Lordship.
Then you file a suit.
They have approach here, Your Lordship. And Your Lordship is not limited here only towards the pension, Your Lordship. This will bear long distance.
Long what?
Because they are claiming their ancestor property also, Your Lordship, because I am the legally wedded wife and even I need the share in the property also. So it's not like only the matter of only this pension, Your Lordship. If the pension we would have settled down, but she is claiming the property also. The ancestor
Where's the property? In Shillong?
no, Your Lordship, in Nepal. So on the basis of this, and Your Lordship will see the writ petition, Your Lordship, and my
Affidavit.
affidavit, Your Lordship, is there that sometimes she is saying that she got married in 2006. Sometimes she is saying that she got married in 2012, and 2 certificates has been produced, Your Lordship, in the department.
Oh, now I remember this case. Yes.
Yes, Your Lordship. It's only for the sake of pension, Your Lordship, it's okay, Your Lordship. But say on the basis of this, if Your Lordship will give any order, any judgment, Your Lordship, it will hamper me and I will face so much hardship, Your Lordship, that I will not able to come out from here.
Hardship means what?
Because she will claim all my ancestor property, everything she will claim, Your Lordship, on that basis of that. And she is saying that she has not given that birth certificate, death certificate, and all these things. Department has given, Your Lordship, that it has been submitted by the writ petitioner only before, not by the husband, Your Lordship. I have that also on record, Your Lordship, here.
So you will hear some other day then.
Right, Your Lordship.
We'll give detailed hearing.
Your Lordship.
As a matter deserves longer hearing. This after 1 week is. We'll look to that. 2 days a bit short.
Yes, Your Lordship. Deeply obliged, Your Lordship.
There are 2 marriage certificates. You brought on a record
Yes, Your
affidavit.
Lordship. 2 marriage
Is that
certificate, 2 the
Your
death
Lordship,
certificate.
the first one was submitted by my husband. When I approached the office for
No,
claim
but
of
it's the 2
pension.
dates of marriage.
Yes, Your Lordship, the first one was wrongly entered, Your Lordship. She
Even
was
they have
married in
given in the
2012.
newspaper, that also is wrong, Your Lordship. And I got RTI also, Your Lordship, that it had been submitted by the writ petitioner, not by the husband. Deeply obliged, Your Lordship.
Where's Mr. B-Deb? Yes.
What's up left, Your Lordship? Then some other day, Your Lordship.
No, it was none of his petitioner. This matter for 2 weeks. Yes.
Apply, Your Lordship.
ये अंदर ले जाओ हाँ